Hello students, welcome to Legacy IAS Academy. Today we are going to discuss about the recent ruling of Supreme Court on the bail law and why Supreme Court has directed the states as well as the central government to make necessary reform and changes in the previous era or British era criminal procedure code as well as the Indian penal code. So in this particular video, we are going to discuss about the present context in which bails can be given to the accused or the bails can be denied to the accused by the courts, and also what are the major reform measures are suggested by the Supreme Court in this particular direction. So first of all, the context in which we are discussing today's issues is because on this Monday, Supreme Court has underlined that there is a very pressing need for the reform in the laws that is associated with the bail conditions. Thus, Supreme Court has also asked the state governments as well as central government to consider framing a special legislation apart from already existing criminal codes on the lines of law that is in the UK. In United Kingdom, bail law is considered as one of the best law in the world, and on the same guidelines, the C has directed that the state governments should also create a separate legislation. And this guideline has been given by a two-judge bench that is comprising of Justice Sanjay Kishan Kaul and M.M. Sundaris, and they have also, while giving a judgment, have issued certain clarifications to an older judgment referring to the same matter that was delivered by the Honorable Court in the month of July 2021. So, first of all, what is the rationale behind the Supreme Court's decision to ask the state government to reform and create a separate legislation on the bail? So, the rationale we can understand from the single point that if you look at the conditions of jail in India, it is believed that almost 2/3 of people who are in jail in India are basically under trials. That means their trial has not been completed, they have not been convicted by the court of any particular crime, and they have not been sentenced in prison for any certain acts of that. So this is something a very highly concerning for a democratic country like India, and that is why Supreme Court also has made an observation that as far as the Indian police is concerned, arrest is a very draconian measure that is being used by them, and however that is something that need to be changed, and Supreme Court has said that arrest is something which should be done only sparingly. It should not be a law, it should be a kind of exception. Second, also Supreme Court has made a notice that majority of the people who are currently languishing in the jails all across India may not even be required to be arrested despite they might have been involved or registered over a cognizable offense. And the third point, Supreme Court has clearly said that many times this is not only a situation that has been created by the police alone, but to some extent magistrates in the lower courts are also responsible because they are basically known for ignoring the rule of bail not jail. That means bail as an exception and bail as a rule and jail as an exception. So this dictum has not been followed by the magistrates in India, and mainly the Supreme Court has said that the reason behind this can be attributed to colonial mindset that is still prevailing in the judiciary and the police systems of India, and that is why for this to change, reform in legislation is highly required. So what is the current situations or law on the bail in India? So first of all, as far as the criminal procedure code is concerned, it has not clearly defined the term bail. However, as far as the Indian Penal Code 1860 is concerned, it has actually bifurcated offences into two types. One is the bailable offence, while other is the non-bailable offence. So as per the criminal procedure code, for the bailable offence, it empowers the magistrate to grant bail for bailable offence to the victim, to the accused as a matter of right. That means if any accused has been arrested under bailable offence, then it is his or her right to get bail from the magistrate. However, situations are not the same for the accused who has been arrested under non-bailable offence. So what CRPC says? CRPC clearly states that accused who have been arrested under non-bailable offences, they are generally considered as a cognizable offence, and the cognizable offences in such matters, it is totally the discretion of magistrate that he or she has to determine that whether there is a valid merit for granting bail or not. If there is no valid merit, then the bail can be denied. And also in such non-bailable offences, police officer can arrest any accused without getting a warrant from the court. So these are the differences as per IPC and the two type of offences in India. So what is the UK law on bail that was signed in year 1976, which Supreme Court has asked other state government to follow? So first of all, the major theme or major we can say objective of UK law on bail was to reduce the size of inmate population all across the jails of United Kingdom, and to ensure that it was also mandated by this particular law that those accused or those people who are languishing in jail, if they cannot afford legal aid due to want of money, the state will ensure legal aid for defendants. The similar situation or similar we can say system also we have adopted in India as well, where we have organizations or bodies such as NALSAs and SALSA, which provide legal aid for such defendants who are very poor economically. And the main theme of UK law and bill that makes it separate from the other laws is that in this law, general right to be granted bail for the accused has been identified. That means bail is not something a prerogative or not something kind of luxury that has to be given to certain accused, but it is a general right that has to be given to all the accused, to all the people who have been arrested. And this is clearly that has been mentioned in section 4 subsection 1 of this particular act. Not only that, the UK law on bail also ensures that if magistrate or the concerned official, if he or she is rejecting the bail of any applicant, it should not be done on whimsical or fancy ground. It should be done only after prosecution has submitted enough proof that there is actual associated risk with granting bail to the accused or to the alleged criminals. And what can be such proof of prosecution? Prosecution has to prove that after granting bail, there is a high risk that person can leave the country, can flee. Second, he or she can he or she can actually take certain steps that can endanger the protection of witness, or he can she can involve in witness tampering or evidence tampering cases. Or third, if there is a high risk of the health, and he and the accused can actually damage himself or the people around him. So in these are the three cases where bail can be rejected after prosecution has proved this. So what has Supreme Court said on the reforms in the bail law? So first point Supreme Court has clearly noted is regarding a separate need of a separate law for bail in India. In this context, it has said that Criminal Procedure Code was enacted during the colonial era, during the British time in India, and that is why it has not been. It has only been even after independence, it has only been slightly modified, and that is why it does not account for arrest as a fundamental liberty issue in itself, because the law when it was made keeping Britishers as a ruling elite in India and the Indian as a subject. So that is the first point. Second point Supreme Court has highlighted is that there is also an issue of non-uniform application of discretionary power of magistrate. So we have many evidences where it has been seen that different accused who are convicted of similar kind of crime or who has been accused of similar kind of crime has been given two different kind of treatment by different courts or different police department. For example, one accused who has committed similar crime has been granted bail, while the other accused has not been granted bail. So there is a non-uniform application of discretionary power of magistrate. That is also a very concerning issue. And due to this, Supreme Court has highlighted that such kind of conditions or such kind of steps are a grave affront to Article 14 and 15 of the Indian Constitution, and thus it violates the right to equality and right to equal protection of law. The second point which Supreme Court has highlighted while recommending the reforms is on indiscriminate arrest. In this regard, Supreme Court has said that in India, the police department has inculcated a culture of too many arrests without even valid grounds. And this is something that has changed, and any arrest that has to be made should be made only on the valid grounds. And not only that, even after arrest, the lower courts must satisfy that the conditions that does not allow applicant to be granted bail must be clearly met. So that is the second point about indiscriminate arrests. In this context, even Supreme Court has clearly noted that even though we have two kinds of instances, bailable offences and non-bailable offences, even in non-bailable offences or cognizable offences, arrests should be made only as an exception. It should not be mandatory, but it should only be kind of depending on the situations, the decision has to be taken by the police officer. The third important point regarding this is the bail application. And in this case, Supreme Court has directed that no insistence of bail application under section 88, 170, 204 and 209 of the IPC could be made. These are the sections that give or grant power to the magistrate to release the accused or deny the bail to the accused. And in this context, magistrate must routinely consider granting bail without insisting on a separate bail application unless and until it is necessary. When can it be necessary? Again, the three situations that we have discussed before. If a person is a high risk of fleeing away or escaping away, if the person is a threat to the nearby people or for himself, or third, if person has we can say wherewithal to involve in witness tampering or evidence tampering. So what we can say on this particular decision of Supreme Court is that SC has directed all state governments as well as the union territories to facilitate standing orders to comply with the said orders and avoid indiscriminate arrests. And while saying so, Supreme Court has actually Supreme Court expect that and feel that it would certainly take care of not only the unwarranted arrests but also the clogging of bail applications before various court, as they may not even be required for the offenses up to 7 years, that is the cognizable offense. That means obviously if this decision is implemented all across different states and union territories, in that case if bail application is not required up to offense of 7 years, so judiciary will also be freed from the extra burden that has been added to it. So hopefully this step by the Supreme Court will be welcomed by all the state and union territories and will lead to changes in the characteristics of judicial system of India as well as the characteristics and composition of the jails and prisons in India. That is all for today's particular issue. Thank you very much.